The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, my name is Fuji Whittenburg and we are about to get started. I will be conducting the webinar Work Visa Options After OPT. Just a little bit about myself. I am an attorney here at Wolfsdorf Immigration Law Group. We are a law firm practicing exclusively in immigration. We're located in Santa Monica, California, and we have offices in New York and Los Angeles. So if you do have questions later, you can always email me or call our office and ask to speak with an attorney. And then if we do decide to move forward, then obviously we can set up an appointment if you're local to either one of these towns. You're also welcome to email me with questions anyways. Just a quick little plug, like us on Facebook and follow us on Twitter. That way you'll receive any of our immigration updates. We send out as many updates as come up, so feel free to do that as well. Okay, let's get started. So for most of you, I'm assuming you're either in school or you're just graduated, or you're looking ahead and trying to figure out what your options are after you graduate. So once you graduate, you do, while you're in school, you have CPT, which is Curricular Practical Training, for those of you who need to work during the school year, and it's, there are specific circumstances. You should speak with your international student office about that. Once you do complete your degree, your program, once you graduate, you're eligible to apply for OPT, Optional Practical Training, which it lasts for 1 year. For those of you who are in STEM degrees, who are STEM students, science, technology, engineering, and mathematics, in addition to that 1 year of OPT, you're eligible for an additional 17-month extension of your OPT. And this is actually really great, but it's limited to those of you with degrees in those specific fields, and there is an actual designated degree program list. I provided the link here. The job that you will be starting has to be directly related to the degree major. So if you graduate with a STEM degree, your job must be also directly related to that. Another condition of the STEM extension is also that the employer that you're working for be registered with E-Verify. E-Verify is just kind of a way for the employer to monitor I-9s and things like that. So it's something they would have to, it's a government-sponsored program that they would have to sign up for, and then your job has to be directly related. And then you could apply for the 17th month extension. So if you have any, questions about that, you should check to see if your degree is on that list, because this is really handy and basically, it gives you an additional, almost an additional year and a half of employment. OPT unemployment period. So I know the economy is a little bumpy right now. I know it's a little difficult in terms of finding a job. So, they do allow for about 90 days of unemployment where, you could, for those of you who are, haven't quite found that position, and then it's longer, 120 days of unemployment for those of you with the STEM OPT extension. Our suggestion to avoid periods of unemployment would be to volunteer within your field of study. So not just, volunteering, kind of randomly saying you're doing something. It should be related to your field of study, and you should also keep track of the service that you have done, whether it is a letter from the organization you're volunteering with, or some sort of email, something that you would be able to keep track of should anyone, should this issue be raised at a later time when you have submitted a visa application and they want you to show that you've been maintaining your status or something like that. So it's a good idea to keep track of that. Let's see. I see a question, and one thing I forgot to mention, if you do have questions, feel free to ask them as the presentation goes on, and then I will try and do a question and answer at the end of our time. And if for any reason I don't get to any of your questions, I will try to, send you individual email responses, or please feel free to also email me your questions. Okay, so getting back to OPT, it's just something that we definitely recommend applying for. It's the earliest you can apply would be 90 days prior to the program end date. Latest is 60 days after your program end date. So there's a window of time where you have to file. If you miss that window, you are not eligible. So you should always check with your school for exact dates. It's actually been a recent issue with students who just graduated this past year where they missed that window based on the dates. So be really careful. You should definitely apply even if you plan on returning home, because you never know what's going to happen. Maybe you intend to return to your home country, or you have a great job lined up there, but then something turns up here, and OPT really is the best way to get that experience with that employer before you apply for a visa. And we always recommend, obviously, it's a good stepping stone to finding that employer. The idea is you work for an OPT, the application, you can apply and fill it out yourself. Usually your school would be able to help you. It is a small filing fee, and that's basically it. It takes about 2 to 3 months to receive the OPT, but once you have it, it's good for that year. So in that way, it doesn't require all of the sponsorship requirements and documents and filing that the H-1B does. So that's why we recommend using it as a stepping stone, so that you do get that experience and you build that relationship with your employer, and hopefully, somewhere during that time they are interested in sponsoring you for the H-1B visa. So which brings us to the H-1B visa. Before we even get started, I will touch on, the cap and the dates and when everything was met. Obviously, right now, currently, you can't apply for an H-1B visa in the private sector. So the visa numbers have run out. The cap has been met. Since June, it has been that way. But now's a good time to start getting prepared and thinking about the April 1st filing date, which I know sounds far off, but really it's less than 6 months away. And the earlier you start preparing, the sooner you can get it in, and hopefully get it in on that, the April 1st start date. So for most of you who are, you graduate, you get the 1 year of OPT, the next step is the H-1B visa, and it's for professional occupations. And professional occupation means one that requires a bachelor's degree in that field to perform the job. It's kind of a very limited view of what a professional occupation is, because a lot of times, obviously, sales and marketing, all of those things are also professional, but those are more challenging fields because they're not as technical, and sometimes the minimum, you don't necessarily always have to have a bachelor's degree for those fields, but some of the more classic titles that would fit under this are the ones listed here, an accountant, software engineer, computer scientist, a teacher, things like that, they fall under there. But it's a very broad category. The H-1B is employer specific, so if you do apply, you can only work for the employer that is sponsoring you. If you would like to work for 2 employers, you can file 2 concurrent petitions. You can have them be part-time. So you work, let's say, 20 hours a week with one employer and 20 hours with another. You can definitely do that, but you would have to file 2 separate petitions. They both require, the same documents and attestations by the employer and everything. So, just because you get one doesn't always mean you're going to get the second one. The H-1B there's a 6-year maximum, and they're granted in 3-year increments. It is at-will employment, which means, you can choose to leave at any time, and also your employer can choose to, terminate the employment relationship at any time as well. There's portability, which means you can transfer your H-1B to a new employer. So let's say you work for a company, for a year and a half, and things are, going well, but a better job offer comes along, you are eligible to file an H-1B change of employer, where you wouldn't be subject to the cap again. You wouldn't have to worry about the April 1st timeline because you were already counted once previously for the H-1B cap, but you are required to file a new petition. And again, each time you file it, you have to submit all of the same documents, your degree, things like that. Also, the information about the employer, the attestations, the wage, and everything else. There is a quota, which I've mentioned several times now. I think most of you are familiar with. It's based on the fiscal year from October 1st to September 30th. The H-1B cap, it's for private industry employers. There are 65,000 visas per year. There's a carve-out, 5,400 Singaporeans and 1,400 for Chileans. There are in addition to those, there are an additional 20,000 for graduates with a master or higher degree from U.S. schools. So if you if you are graduating from a U.S. school with a graduate degree, master's or higher, you're eligible to fall under the 20,000 extra. And if for any reason, let's say next year, by the time you file, you have a master's degree or a PhD and you're filing and the 20,000 has been met, you automatically still qualify under the bachelor's cap, which is the 65,000. So you have more opportunity of being selected. So this past year on June 12th, the USCIS announced that the H-1B cap was reached, and it was the shortest H-1B filing season in several years now. It was only about 3 months. So the earliest you can file is April 1st, and you can't actually start on the H-1B until October 1st. So, previously, a lot of people have heard stories. We would have, what we call March Madness, not related to basketball, but it was a computer-generated lottery system where everyone would file on the 1st of April, and they would just have a random selection process. And if you got a receipt notice, that meant your petition was selected. It didn't mean it was approved. It just meant that it was selected, and then it would be adjudicated, and lots would get rejected. But because of the economy and everything, the cap was no longer met that first day or that first week. It actually stretched out for a while. There's actually a typo here. I'm sorry, in my PowerPoint. But as you can see, it opened on April, and in recent years it stayed open until December and January and November. And then obviously this year it was only until June. So it's a good sign. It means employers are hiring. It means that hopefully the economy is moving forward, and it means good things for all of you that are listening. There is something called cap gap relief. So as I mentioned, once you graduate, usually, and this is based on a more traditional schedule, but basically you would graduate in May, you have OPT for a year, it carries you to the next year. You would have a little bit of a gap from the time that you file, April 1st, or around that time, until October 1st. So during that summer, previously, a lot of times students, you would have to either take the summer off and not work, or go home and come back. And so what they've provided now is cap gap relief. So basically, as long as you file the H-1B petition, it has to, obviously after April 1st, as long as you file it before your OPT expires, your F-1 status is automatically extended so you can continue to be here, and then your employment authorization is also automatically extended so you can continue to work, which is really, really the key here. So for all of you that are on OPT, be really cognizant of your OPT expiration date. If you are applying for an H-1B in the spring, make sure you're very aware of that date. You talk to your lawyer about that date, your employer. Just really make sure that that date sticks out in your mind, because you want to make sure that you file your H-1B prior to that date so that you are eligible to continue to be here and to continue working for your employer until October 1st or when the petition is approved. Here's a little general timeline for those of you who are graduating. Let's say you just graduated and you're in your OPT period now. You would file for your H-1B. The earliest, obviously, would be April 1st of next year. and then let's say so your OPT ends in July, the gap period would automatically extend you from July to October, which is really, really great. So there's no gap. If for some reason your H-1B petition is not selected, or if it's denied, your cap gap relief ends upon that date, and then you have a 60-day grace period from that time to kind of sort things out and figure out what you need to do. So it doesn't backdate to the expiration date of your OPT. A lot of people are worried about that, so that's kind of nice. In terms of the H-1B process generally, I mean, this is a broad overview. For those of you just, for your own knowledge, it's a little technical, so I don't want to go too far into it, but there are two agencies that are involved. The Department of Labor, which is the first step where, we have to verify the employer identification number, and then we submit an LCA, and in that LCA, that's where the wage attestations are made, and I'll touch on prevailing wages in a bit, but it takes about a week to be certified, and then there's the USCIS portion, which is the actual petition where, it's the support letter, the forms, and the government filing fees. Employer obligation. So as part of the petition, the employer has to make attestations that they are paying you at least the prevailing wage. And you can find the prevailing wage for your job category, and I get emails about this all the time. So this time I included the link. If you go to the link that I've provided here, you can go and, it's based on your geographic area. So, you go, if you're in California, you go to California, and then Los Angeles, within Los Angeles County, what's the minimum level 1 wage for, computer software engineers. You can look it up that way and see. So that's the minimum that the employer has to pay you, and there's no benching. So this means just because it's a slow season at work, he can't, your employer can't ask you to not work so that they can withhold pay. So that's what that means. And then in terms of termination, if unfortunately things don't work out, or if there's, layoffs or a reduction of workforce or anything like that, they must offer the employer must offer you reasonable cost of transportation home, and they are required also to notify USCIS. So this is also a very common question. It's one of those who will ever know. Well, they have a requirement to let USCIS know. So and oftentimes the attorney is aware of this and will handle it and take care of it. There's no grace period or anything like that beyond termination. So hopefully, employers generally, will give you notice, and then if they give you enough notice, you'll find a new employer and switch over your H-1B, and you won't have to worry about anything. This is a big question always: who's responsible for the fees? How much are the fees, and who's responsible for the fees? I mean, just ballpark, I would say the total of the H-1B would cost about $5,000. Including both the legal fees and the government filing fees. The government filing fees are really, it's about half of it. The training fee is one fee that must be paid by the employer. That's, it's explicit. It has to be. The other fees, they may be paid by the alien or employer. Arguably the employer should, you should try and have the employer pay for all of it. In the instance where you are being paid right at the prevailing wage. So I give an example here. Let's say the prevailing wage for your job category is $60,000, and your salary is exactly that, $60,000. You can't pay for any of the legal fees or filing fees or anything, because it'll drop you below the prevailing wage. They actually count these fees against your wage. So you can't. But if, for instance, prevailing wage is 60 and your salary is 70, then then it would no longer be an issue. But they do have to pay the one at the very least is the training fee. And I do have to mention H-1B audits. There has been an increase in fraud investigations and worksite visits. I just had a call yesterday when, just to give you an example, where, somebody was saying, oh, I have a friend, he has a company, he said he would sponsor me, he'll, write whatever he needs to write in the paperwork, and, those kinds of things, funny business. I mean, you really can't, because we're hearing more and more about, investigators being sent out to the field. They'll just kind of pop in one day, ask the receptionist, hi, where does John, so-and-so work here? What does he do? Where does he sit? And they'll ask, so they'll ask to see, where you are. They'll talk to you, ask you about what you do, so that it matches the petition that was filed. And then they can also ask, to speak with your employer or supervisor. And then, they are authorized to ask to see payroll records to make sure that you're on payroll and you've actually been working there. So, no funny business. That's the point there. Okay, so this is where we are now. The cap has been met, so now what? What are your other options? So whether it be, now for those of you who missed the cap and who are in OPT status right now, and don't want to wait until next year, or for anybody else who's listening, there are other options. There are H-1Bs for cap-exempt organizations. So that means that there is no cap. You don't have to worry about the April 1st, October 1st, those kinds of timelines, or the 65,000, visas. And this applies to, and they're, very specific institutes of higher education, so universities and colleges. If you want to, if you get hired to be a, assistant professor or something like that, you don't have to worry about the cap. Nonprofit organizations affiliated with institutes of higher education, nonprofit research organizations, and government research organizations. So it's really specific to the organization that you want to work for, and you have to make sure that they qualify under each of these, or under one of these. You can switch from cap exempt to cap subject employer, from university, for instance, to private industry. You would be subject to the H-1B cap because you've never been counted. If you do want to go from cap to cap exempt, you wouldn't have to worry about it. Some other information, the H-1B extension, the cap doesn't apply to extensions. So again, once you've been counted, that first time you don't have to worry about it again. You can extend, in 3-year increments for a maximum of 6 years. And then there is a remainder option. So let's say, for instance, you had an H-1B and then you went back to school, and now you're switching back to the H-1B. Whatever time you didn't use before, like this happens a lot for people who are in H-1B, and then they did their bachelor's and then they want to go back for their master's, and then they want to go back to the H-1B. And in that case, you could go back and use up your leftover time. You can use up any time that you spend abroad. So for those of you who are just starting out and looking ahead, so over the course of the next, the 6 years ahead, anytime you go home, whether it's, home for holidays or, or not even home, but abroad, if you go outside of the U.S. for a trip, you go to Europe, you go on a family vacation or something, if you keep track of that time, that actually adds up, and all of that time can actually be, we call it, you can recapture that time and add it back to your current H-1B time. And over the course of 6 years, I mean, we have clients, it adds an extra year or two sometimes to your H-1B time. So it's something that you should keep track of through flight itineraries, tickets, flight tickets, and things like that. And then the last thing is, if you are outside of the U.S. for more than 1 year, you can either recapture the time, left over, or you can ask for a new 6 years, but you would be subject to the cap. What happens when you reach 6 years? Is 6 years really 6 years? It is 6 years. I just talked about recapturing time, and then, specific to the green card process, as long as it's filed, about a year before your H-1B expires, you can continue to, there are obviously you have to make sure that, your green card application has to be pending for more than a year, and you can extend it beyond the 6 years, which is what a lot of people, which is my second bullet point here, for those of, for those people who are stuck in backlogs, they do this so that there is a way to extend the H-1B beyond the 6 years. Top 10 myths about the H-1B visa. There's no H-1B for a small company or a startup. That's not true. We do them all the time, as long as the company, is a viable company. And a lot of times the smaller companies, they have, a lot of private funding, which, we can discuss, or if they have a really strong business plan. It's definitely doable. It's just you have to really show that it's a legitimate business plan and idea. There's an office, and the company has enough money to cover overhead and operational costs as well as your salary. Another myth is, you have to advertise for the position. This is a green card, actually, for the PERM labor certification process. That there's a recruitment requirement, but not for the H-1B. For the H-1B, there is a posting requirement where you have to post, at the office, but there's no obligation for the employer to show that there's no qualified U.S. worker. You can change employers if the cap is reached. You don't get a new 6 years every time you change employers. And then again, the biggest one is this 10-day grace period after a layoff or after you leave. There's no, basically status terminates. There's no 10-day grace period. You can go to school part-time on the H-1B, which is nice for those of you if you want to, maybe pursue a higher degree. You can go to school part-time. You can't file for, and what I was talking about, the $20,000 extra under the master's cap, you can't file under that until you've actually completed the degree. So for those of you who are in your, the final year of your, master's program or doctorate, you can't file in that under that higher category until you've actually completed the degree requirements. Even though, let's say you want to file April 1st, but graduation isn't until, for instance, May 15th or June 1st. If you can get a letter, from the registrar saying that, this is confirmed, so-and-so has completed all degree requirements and is being awarded, this degree, then you could file under that cap. But otherwise, if you have a dissertation or, if you still have other things that are kind of looming out there, you can't file under the higher degree cap. There's no electronic filing actually right now, so that doesn't apply. Premium processing, people always ask whether that helps or hurts. To be honest, I don't really see the point unless you're really rushed. It doesn't lock in a number and it doesn't help. And filing multiple H-1Bs, you can't do that either. It becomes frivolous filings. So let's say, you get the next year, you get the H-1B, and for those of you who are married or have children, the dependent visa category is the H-4. There's no employment authorization, but they can go to school, so that's good. But that's it. Some other options, I know someone had asked about this, they're the free trade agreement visas, so there are H-1B ones, which I had mentioned previously, for Chileans and Singaporeans. There's a TN, NAFTA visa for Canadians and Mexicans, and you can check there. It's the only issue with the TN. The TN is great for Canadians and Mexicans only. You have to be, and it's not for permanent residents, it's for Canadian Mexican citizens. It's a very limited job occupation list, and it's in the TN appendix, and I listed the site here if you look at it. So it's a great option for, alternative to the H-1B because, there are no timing issues. You can apply for it at any time, but it's a very limited list of occupations. And so it's just something to check. Hopefully you're eligible and it works. For Canadians, they can apply at the border, which is really nice. They literally, we prepare it and they present it at the border when they're coming in or at the airport. Mexicans, we prepare it and then they actually present it at the U.S. Embassy in Mexico at one of the, consulates there. And it's adjudicated, right on the spot. So for these two, there's no government filing fee, which is nice, and it helps cut down on costs. And the wait time, obviously, is pretty quick because it's kind of, adjudicated on the spot. And last free trade agreement says E3 for Australians. I don't know, how many Australians are listening, but for those of you who are Australian, there's the E3. And again, just like the TN, I didn't mention this, it is for professional occupations. You do have to show that you have a bachelor's degree, or the equivalent of a bachelor's degree, I should say. For those of you who have degrees from your home countries, a lot of times, we use a couple of companies, but you can get an education evaluation to show it's the equivalent of a U.S. bachelor's, and that's also a requirement for the E3. The E3 is nice, but you do have to apply initially at the consulate in Sydney. But also, same thing, it's adjudicated on the spot. And really quickly, I should mention, so for TNs, spouse children is the TD, so they do have dependent status, but they don't get work authorization. For E3s, the spouses do get work authorization, so that's also something to keep in mind. There is a J1 visa for exchange visitors, and this includes interns, trainees, and then also professors and research scholars. So I'll just kind of quickly touch on these. This could be a good alternative to the H-1B for those of you who maybe, are in that in limbo phase right now and aren't sure what you want to do. There's this category. Trainee, 12 to 18 months. It's one or the other, 12 or 18. You have to show that you have basically a foreign, degree, post-secondary degree, and 1 year of work experience outside of the U.S., or you show you have 5 years of work experience outside the U.S. So this doesn't really help those of you that are here currently. And then interns, here the requirements are here. It's that you're currently enrolled abroad, outside the U.S., or that you've graduated, that you recently graduated from a foreign institution. The professor research scholars is for university and research positions, academic appointments, short-term scholars. So any of you who are interested in working at a university or doing research, this is, this is actually coordinated directly with the school. You have to be careful with the J1 because there is, for some countries, there's a 2-year home residency requirement, which means that you're required to, return home to fulfill 2 years at home before, changing your status in the U.S. And for some categories, this can be broken up over a period of time. So I have, I know some people who, go home over a period of time, 3 months, 3 months, 3 months to fulfill it. There's also a waiver that you can get. It's a bit complex, but we do have some attorneys here who definitely specialize in these areas. So let us know if you have any questions about the J1 or, whether or not you're subject and things like that. There's for F1s, there's a 60-day grace period. For Js, there's a 30-day grace period at the end of the term. Something to keep in mind. Another option is the H3 trainee. In this application, you file it through USCIS, and the company would sponsor, and it would be really for training, for training purposes. It's not for productive employment. So this is for, people who really want to, learn more and get, real on-the-job training. As part of the application, you have to show that the training is not available in your home country and that it will benefit your career abroad. So, ultimately you plan on, learning this skill and taking it home, that you already have a job offer. Or there's a, for instance, if there's a company that has a branch here and a branch at home, you would be getting the training here to take it home to the company, abroad. Okay, which brings me to the next option, which is the L-1A Multinational Executive and Manager Visa, or L-1B Specialized Knowledge. The L visa, it's a great option for those of you who have had, a lot of people have a long career abroad at home. If you worked for a larger company that had a branch, there, and they also have a U.S. branch, you have to show that you worked for the company for at least 1 year abroad, and I haven't included it here, it has to be within the immediately preceding 3 years. So for those of you who have been here for, a while, 4 years or something, for, if you're in college or you're in school, this may not necessarily apply. So there is a, it's confined. So let's say you're filing this, next month, you have to show at least, 1 year in the last 3 years have been, working abroad as an executive manager or a specialized knowledge individual. You have to be coming to the U.S. to fill, to be filling one of these roles, and it's really based on the corporate relationship of the, the company abroad and the U.S. company. So, usually it's a parent subsidiary or their affiliates, something like that. But this is a really great option, possibly even looking ahead for those of you who are here and you have a job offer, abroad possibly, or you want to work for a company, a large company, they have an office in, I don't know, Spain, and you want to go. So if you work there for a year, a couple of years, this could be an option for you down the road to come back and work at the U.S. office. So it's really something to consider when you're looking at the big picture. There is such a thing as a new office L for new companies. So even if there isn't a U.S. branch, but you worked for the, the company abroad, that company, if they really, want to hire you back or have you kind of start off the new office in the United States, there is such a thing as a new office L. They're a little bit, it's a little difficult because you have to show, that the company is really set up, and it's only good for 1 year. But if you can show at the end of that 1 year that the company has grown and increased its sales or, contracts or clients, and you've hired a couple of employees, then you could extend it. The L1A, which is the executive manager category, is valid. You can get it for a maximum of 7 years. And the L1B, which is specialized knowledge, is a total of 5 years. Spouses and children are eligible for L2 visas. And the good part about the L visa is that spouses also get a work permit, the unrestricted employment, which is nice. So, just like the E3, the Ls also get work authorization, and then there is a green card, process that relates kind of, almost directly to the L visa. The next option, I'm getting a lot of questions, so I'll be sure to, if I don't get to them, right now, I will try and get to them during the Q&A, and if I don't get to them during the Q&A, I will, or email me, actually, if you can. Just email me the questions, or I'll try and respond by email. The next category is the E-Visa category, and it's broken up into 2 subcategories, E1 and E2. And this is really based on your home country having a treaty, with the United States. And there's a treaty country list, and I list at the, www.travel.state.gov. That's the State Department website. You can check the treaty country list to see if your country is there. This is really good for those of you who are entrepreneurs, and business savvy people who want, you've decided, what, I don't want to work for somebody else. I want to set up my own business, my own company. I have, I have the funding, so I want to do that. So this is a really great option. It's just, you have to make sure first that you're eligible, and then, then there are certain requirements, to show, but it's a good one. At least half of the company must be owned by the treaty country person, so at least you should own at least half of it, and then the other half can be owned by someone else, or the whole thing could be owned by you, or people from same nationals as you. You can start up a company, or you can buy a company. When you hear about somebody buying a chain, like a Starbucks or a Quiznos or something, you can buy a company as well. So the E1 is a treaty trader. You have to show 50% trade between your home country and the U.S. So this is really for the import-export business. I can give you an example that's not as obvious. There is, like a production company, for instance, where the person is a French national and they have a visa here, and what they do is they do all of the production, like they do a bunch of commercials for French clients, but they do them all here in the United States with the U.S. company, and then they basically, do the business here, but then they export the product, the finished product, the TV commercials, they send it back to France. So it's kind of, it is pretty interesting. It doesn't always have to be like a tangible product. The other category is the investor visa, which is, this is, a lot more common. This is where you put in a bunch of money and you start your own company, whether you want to start a restaurant or you want to start a clothing company or you want to start a production company, like I just said. I mean, this is really that category. And then you would be either the principal investor or, somehow show you're an executive manager or essential employee and have a national, that you're a treaty country, national. And then, so the E visa is great. And then the, spouses and children also receive dependent visas, and spouses can also apply for a work permit under this one as well, just like the L and the E3. O visa, so this is another category. It's the extraordinary ability category, and this is really for those of you who are really well established in your careers, or are tied to, I guess, people who are really well established. The O1A category is the higher category: science, education, business, or athletics. So this would be for the high-profile, scientists, researchers, professors, executives, business people. O1s, I've done, I guess, surfers and fencers, fashion models also. They fall under this category. The second category is arts or motion picture TV. So this includes, musicians and visual effects people and graphic designers, sound engineers, and then, actors, directors, writers. These are all, within these categories, and really it's broken up, the classifications. It's just about the standards and the criteria that apply that you have to show that you meet. But it's really for persons of extraordinary ability. There are, O2 would be essential support. So really the O2, I'll give you an example, a director and then an assistant director, for instance. So the director would be the O1, and the assistant director would be the O2, and you just have to show that the relationship there, that they've worked together before in the past, and they're, they're continuing, to work on this film together or something like that. The dependent visa for the O1 is the O3. There's no work authorization with this. Really quickly about the standards. I know for those of you who have just graduated from school or who are still in school, this might seem like kind of a burdensome, I don't know, you probably wanted to kind of blow this one off. But it is something to keep in the back of your mind. It's a good one, too. So really quickly, it's, O1A is the, like I said, that's the higher category. You have to show you're one of a small percentage at the top of your field. O1B, the arts and then film and TV, they have slightly lower, slightly lower standards, legal standards, in terms of the burden and the evidence. But extraordinary ability, you just have to show extraordinary achievement. So some of the types of evidence across all categories, it's things like awards, memberships, press, written about you, any articles that you've written, if you've been asked to be a judge or sit on a panel or asked to be a speaker at a conference or at an event, if you happen to work at, have a very important role with a well-known company, you're paid particularly well. you can get reference letters, and then people in the, like, let's say movie industry, the kinds of evidence you would show would be like your IMDb credit. And then for business people, usually it's they turned around a company, or they did really well, or they were paid $1 million a year. It's things like that. So this brings me to my next slide. It's just overall general job search tips. Obviously, I know it's a tough time, but at the same time, do what you can and really just network as much as possible. Social networking sites are obviously really big. Your school should be a great resource to you. And then, local Chamber of Commerce where you live, that's always a suggestion. And also your local embassy and consulates. Sometimes if you go to your, the Los Angeles consulate, for South Africans, they may have job postings where they're U.S. citizens who are South African nationals. They want to hire somebody, or they want to advertise to you guys. So it's a good idea to check that. And then just something to mention would be that you're a stronger candidate because of your international perspective. People always ask me, what should I say in an interview, that kind of stuff. Hopefully your your resume speaks for itself, but when asked that question, I always, suggest pointing out, I think diversity, cultural diversity is good, and it is important in a global economy, and that it would give your employer a competitive advantage, that you bring something unique. Those are the kinds of things I think you should really highlight in that kind of setting. Okay, so the next category that we're going to discuss is the green card, the ever-popular green card section of the presentation. There is such a thing as green card lottery. And unfortunately it just closed, so hopefully everyone listening, if you were eligible, you did register. I really, really hope that you did. Right now it's closed. If you didn't and you missed the window this year, there's always next year. The registration period is always, basically the beginning of October to the beginning of November each year. And again, you go to the State Department website, travel.state.gov. It's called the Diversity Visa Green Card Lottery. There's no application fee, but you have to be eligible, and it's based on your country of birth, not citizenship. So I've listed here some countries that are not eligible, and so they're listed here. You can cross-charge to your spouse's country of birth. So let's say, you're from Brazil or China, and you weren't eligible, but you're married to somebody who is, then you can apply under your spouse's country of birth. So just in summation, green card lottery is closed now, but you should apply. You should apply every year. People do win. We have clients every year. People contact us. They all, people do get it. It is real. Don't pay anybody to do it. You can just apply yourself at the link that we provided here. Our office can help you if you have any problems, doing it. Of course, we can do it, but I really do suggest, I think, it is an application that you can handle as well. And do it if you're eligible. Okay, so then beyond green card lottery, then there are two remaining categories left. There are family-based green cards and there are employment-based green cards. I'll touch on family-based green cards now. Really it's going to be based on the immediate relative petition is if you're married to a U.S. citizen, if your parent is a U.S. citizen, or you're a U.S. citizen and you want to sponsor your parent, there are immediate benefits. So for immediate relatives, immediate benefits, you get a work permit and travel authorization within about 2 to 3 months. It's fairly quick processing. If you marry a U.S. citizen, it's a conditional green card at first. If you're married for less than 2 years, and then at the end of the 2 years, you're required to show either you're still married or that you're not, but the marriage was entered into in good faith. So it's definitely an option there. In terms of an adult child, this is a common question. If you have a U.S. citizen child, let's say they're 5 years old, they can't sponsor you. They can sponsor you once they reach the age of 21. I've listed some categories here. I'm not sure. The dates change a lot, but in terms of backlogs, I know that there are some pretty significant backlogs. Spouses of green card holders, that's legal permanent resident, or LPR, is the same as a green card holder. And, for instance, it's 4 to 5 years. I just checked the December bulletin. It's about 2 years. But, they list them all here. Brothers and sisters of U.S. citizens have the longest wait time right now. I think it's 11 or 12 years. So it's not a quick solution, but it's definitely something where, depending on your circumstances, it's an option. So that's family-based, which brings me to employment-based. Employment-based, we call it EB1 through EB5. So employment-based, EB is employment-based. 1 is first preference, just to get you familiar with the terminology. EB1, first preference, it's for aliens with extraordinary ability. So it's just like, the O1, but a higher standard, more evidence, really people who have reached the top. It is really going to be the creme de la creme, the top of the field. And then also the L1, what I talked about, there was a green card that was, similar to the L1. That one also falls under this category, multinational executives and managers. So you've got aliens of extraordinary ability, outstanding researchers and professors, and executives and managers. The EB1, just really quickly, EB1 categories has the quickest processing, basically, for the most part. That category is current. There are not backlogs, but it's a very high burden of evidence. EB2, so employment-based, second preference is for advanced degree holders. So you have to show, it's master's or higher, or a bachelor's plus 5 years of experience. Also under the EB2 category is what we call SCED Group 2. So it's for aliens of exceptional ability in the arts, sciences, or performing arts. And then there's a national interest waiver. The first two, advanced, those require employer sponsorship. EB1, I forgot to mention, is self-sponsoring. It doesn't require employer sponsorship necessarily, the EB1, the very first one, aliens of extraordinary ability. The other two do. Under EB2, it requires employer sponsorship as well, except for the last one, national interest waiver. If you can show that you are, obviously you have to show that you are extraordinary and, you've had, a certain level of achievement in your field, but you also have to show that the field is important to the United States, is in the national interest of the United States. So it's a pretty unique category, but it's also a very interesting one, and one that I think a lot of people have been exploring a lot more, and it doesn't require employer sponsorship. So that's something, to think about. And then EB3 is a third preference. This is really kind of the most common category where most people with, most of these green card applications fall in this third category, and it actually has, because of that, it's the most backlogged. So EB2 versus EB3, why does it matter? It matters because of retrogression, because of processing times. And two of the most backlogged countries with the longest waiting times are China and India. Basically the process, EB1, separate. EB2 and EB3, the process is, the perm labor certification process. So this is what I had mentioned earlier under the H-1B, where the employer has to conduct good faith recruitment efforts and show that there are no authorized or qualified U.S. workers to do the job. So basically, they would get started, they would advertise, they have to advertise in the Sunday paper, on their website, through employee referral programs. I mean, there's certain, they have to meet certain, follow certain steps in terms of recruitment. They receive resumes. Basically, they're advertising for your job. And once they do receive a resume of somebody who is qualified, they don't have to offer that person that job, but they are required to stop recruitment and basically start all over again if they want. I mean, if they want to hire the person, of course they can. But as you can tell, so this is a little tricky, especially when the economy, there are a lot of people looking for work. So when a job is advertised, oftentimes HR people or companies are kind of, obviously flooded with resumes. So they are required to do this step, but hopefully you get through it. And in our office, most attorneys kind of guide you through the process to help with that. The second step is the I-140 immigrant visa petition, which is, the petition. It's about the job and everything. And then this is where the EB2 versus EB3, the visa bulletin, comes into play. Because if your priority date is not current on the visa bulletin, you can't actually file the third step. So what happens is a lot of people, are stuck at step 2 and can't file, the third step. Or they have filed the third step, but based on the visa bulletin, they are, backlogged, or they're not current. This third step is what gives you work authorization and work and travel authorization. So here I cut and pasted the December 2012 visa bulletin just to give you guys an idea of what it looks like and what it means. So on the left-hand side, it's employment-based. So first, second, third, those are the EB1, EB2, EB3 categories. And then across the top, all countries are lumped in that first, the second column, and then China, India, Mexico, Philippines. As you can see, first preference, they're all C, so that means they're all current. So that means there's no backlog. You can file, and it'll be processed pretty quickly. EB2 for all countries except China and India is current. So as you can see, for China, it's about a 5-year backlog. Indian nationals, it is about let me do quick math, 8-year backlog, which is it's a significant amount of time. Each month the visa bulletin is updated. Every now and again it will jump ahead or fall behind. It's a little unpredictable. So we monitor it obviously every month and notify clients when they are current, and people obviously monitor it themselves as well. Because once you are current, you want to go ahead and file that third step. And then, EB3, which is the kind of more, kind of common category where the job requires a bachelor's degree, not higher degree, is, as you can see, EB3 is mostly about a 6-year wait time, and for Indian nationals, it's about a 10-year wait time. So something to keep track of. It's updated monthly. Again, travel.state.gov has all of this information there. So, deciding between the two, again, I know that a lot of this is really technical, so I will try and kind of gloss over so we can get to the Q&A part. It's based, the whole application really is based on the actual minimum requirements for the job that's being advertised. Granted, it's your job, but it's not based on your background. It's based on the job that's being advertised. Like, let's say, for instance, it's an accountant. It's, when they do the recruitment and fill out all the documents, it's really about what's the minimum requirement. Does the person, need to have a bachelor's degree? Yes, probably. Do they need to have 5 years of experience? Possibly, yeah, if it's a senior accountant. So it's really more about the job and not about you. Hopefully, you also obviously need to, meet those requirements. But that's something people are generally confused about. Tricks that won't work. You can't tailor the minimum requirements to your experience or education. You want them to match, but it shouldn't be tailored to you. And imposing foreign language requirements, again, I understand it's helpful in some respects, but it's really a red flag in these processes. So you have to be able to, be ready to show what the business necessity of this foreign language requirement. Just, hopefully, you can start at any time. Obviously, a lot of times, you want to get to know the employer and vice versa. They want to get to know you, and you want to be comfortable. So, no later than, I would say, probably you're in your 4th year of H-1B, you should probably get started or start thinking about the green card process. It is a long one, so you want to make sure that you start so that you are able to, continue to extend your H-1B beyond the 6 years. If you're, as long as you're eligible, you want to be able to do that just in case there is, if you're caught in a retrogression situation. Really quickly, the last 2 employment-based green card options are the religious worker green card, and then the $1 million investor green card for those of you who have generous friends or family. There is a $1 million green card. There's also a $500,000 one, and that's where there are regional programs set up, and you can invest. The $1 million one is you just put in. I'm not trying to make it sound that simple, but you do put in $1 million. You have to show that you've created 10 jobs, but it's really you have full discretion over the business and what you want to do with it and all those things. You do have to demonstrate a few things. It's not just put $1 million in and you get a green card. You really have to show that you've created employment and all of these things. But the regional center program is great for some people because it's a pooled investment, so it's more of a passive investment. So for the entrepreneurs, this isn't that great because you don't really have a whole lot of say in it, but they are pre-approved programs, and you invest the money in. I don't know what the return is. You would have to obviously research and find it out, and there's a 3-step process, but at the end you do get a green card. Okay, so this brings me to the Q&A portion. I think we have, about maybe 10 to 15 more minutes. What I can do is I'll try to scroll through here and answer some questions. Before I do, I just wanted to thank everybody for listening. Feel free to continue to listen for the Q&A. We do post the presentation. You can listen to it again on our website. It might take a day or so for us to upload it, and then also the PowerPoint should be available as well. So we get a lot of questions about that. So please be sure to check back on our website in about a day, and then you can also register for our newsletter, which is a great way to get information, things like, whether when the cap opens, when the cap has been met, any changes in the law, you never know, something might help. Please like us on Facebook, follow us on Twitter, and then again, if I don't get to your questions, please feel free to email me. My email address is F as in Frank, last name Whittenburg @wolfsdorf.com, 1-800-VISA-LAW. There's our website, wolfsdorf.com. I appreciate everybody who registered and who listened, and I wish you the best of luck. And again, feel free to email me if you have questions. What I'll do is maybe grab a couple of these questions. A lot of them really are pretty lengthy, so I will try to see what I can do. One common question actually here is, what is the advantage of OPT over H-1 visa if I'm working? If your employer wants to sponsor you for the H-1B, and and this is next spring, and you're able to, then yeah, of course, go ahead and file for the H-1B. We just suggest the OPT first because it's kind of a low pressure way to work for the employer. A lot of times employers are a little resistant to sponsoring, or they're not sure about the process, so that's why we suggest that. But if they're willing to, then by all means go ahead and definitely use it. And then also the OPT, it just kind of adds an extra year. So you get a year of that, and then your 6 years of H-1B time. So that's the other reason why we suggest it. I did talk about the TN visas for Canadians, so if you do have more questions, please let me know. And then somebody asked, is there an option to begin OPT or CPT before the 9 months F-1 status? From my understanding, no. You do need the 9 months before they can authorize you for either CPT or OPT. Obviously, the best place to find that out would be through your school, through the International Student Office, because they are the ones who actually authorize it. But no, I mean, I think it's pretty standard that you can't. Another question, do you recommend that gap relief be stamped on a student's I-20? You know, in a perfect world, that would be great, but a lot of times schools won't, from my experience, they, don't do it because it's, it's extra work, and you don't always have the right documents. But as long as you can show that you have your I-20 and that you have your OPT and you have the receipt notice showing that your H-1B petition was filed before your OPT expired, I think you should be good. And if you want, take it to your International Student Office and see if they'll endorse your I-20, of course. It's always better to be safe than sorry. Someone's asking if I need a lawyer for the OPT and H-1B process. You don't need one for the OPT process, but I do advise getting one for the H-1B process. It has grown increasingly technical. I just realized he left. Let's see. To use the master's cap, does the job have to require a master's, or is it enough to have the degree? Well, it has to be a professional occupation, so it has to require someone with at least a bachelor's degree. But if it doesn't require a master's degree, I think it's fine as long as you have it and the job is a professional occupation. I'm going to answer one more, and then the rest of them I'll try to respond by email. I have another question about status for the children and spouse of an H-1B. It's H-4. Sorry, I'll answer one more. That one was pretty straightforward. I'm graduating with my bachelor's degree this May. However, I'm staying an extra semester to finish my minor. I will then be done by next Christmas, 2013. When do I have to apply for my OPT? So as soon as you are finished with your program, even though you're graduating, I'm assuming that means you're walking. It's really based on your program end date. So I would speak with your International Student Office or your advisor about what the actual dates are. But if you're still in school and you haven't officially graduated until you finish your minor, then I believe you would have to apply then. But you should definitely check with your school to be sure about those dates, because it's really specific to you and your program, as well as the school and the registrar's office and how they annotate things. Okay, again, I'm sorry. Some of the questions are really lengthy, so I'd prefer to try to respond to them by email. Again, I really appreciate everyone joining us today, and I hope you have a nice weekend. Best of luck, and feel free to email me if you have any follow-up questions. Thank you.